Hello and welcome to the latest podcast from Employee Management dealing with recent developments in employment law. My name is Chris Nagel and I head up the HR support side of the business. I also represent clients at Employment Tribunal, and it's a recent well-publicised change in this area that I'll be presenting on today. In the third quarter of 2013, the number of outstanding tribunal claims hit a staggering 625,000. Accordingly, following the government's decision to hike qualifying service for unfair dismissal claims from 1 year to 2 in April 2012, it launched a three-pronged attack to rapidly reduce the burden of claims on the tribunal service, which comprised the introduction of tribunal fees, capping compensatory awards in unfair dismissal cases, and requiring potential claimants to engage in early conciliation through Acas before lodging a claim. Early conciliation replaced pre-claim conciliation, or PCC, an Acas service introduced in 2009 as a way of potentially resolving disputes without the need for any legal claim to be submitted in the first place. According to Acas, settlement was achieved in a quarter of PCC cases, and half never resulted in the tribunal claim being lodged. PCC differed from early conciliation in that Acas concerned itself only with those individuals who appeared to have the basis of a claim and an intention to exercise it, had exhausted internal procedures, and had indicated in advance that they wished Acas to contact their employer or ex-employer to see if the dispute could be resolved voluntarily. These cases were therefore selected precisely because there was a good prospect of settlement being achieved. Early conciliation cases are not sifted in this way. Whether there is possible grounds for a claim, whether the individual has followed internal process, and whether a potential claim is likely to be settled, early conciliation will apply regardless, except in relation to a very limited number of exceptions. The regime was launched on the 6th of April 2014, albeit on an optional basis initially. It became mandatory from the 6th of May 2014 onwards. As to what the process involves, the employee or ex-employee contacts Acas either by telephone or by completing an online form, and this results in the normal time limit for submitting a tribunal claim being paused. A conciliation officer is then assigned to the case, and he or she contacts the individual within 2 working days to confirm basic case information and explain the mechanics of the scheme. If the individual expresses a wish to try and settle the dispute prior to making a claim, Acas will then contact the employer. If both parties agree to take part in conciliation, the process will commence and run for up to a month from the date on which the individual first contacted Acas. Important to note here that this period can be extended by 14 days if such an extension is agreed to by both parties. If the dispute is resolved through early conciliation, Acas will formalise the agreement on a Cot 3 form. If the dispute isn't resolved through early conciliation, or if the individual or employer doesn't want to take part in the process, Acas will issue a certificate confirming that the prospective claimant has complied with the early conciliation requirement. That certificate will include a number which must be cited on the ET1 claim form, otherwise the tribunal will reject the claim. Conciliation can then be offered as normal up to the claim being submitted, and then up to the full hearing. So what impact has the scheme had since its introduction? Well, statistics published in September 2014 indicated that settlement had been achieved in 16.5% of cases. An additional 19% didn't result in a tribunal claim. The latest round of stats, published in November 2014 and summarising the first 6 months of the scheme, showed a further improvement insofar as 18% of cases resulted in a Cot 3 settlement, and of those cases that weren't settled, less than a third progressed to a tribunal claim. Other figures of interest were that only 10% of individuals chose not to participate in early conciliation once they contacted Acas, and similarly, only 10% of employers rejected early conciliation when Acas contacted them. These results indicate that the scheme has proved to be a qualified success. Certainly, early conciliation presents an additional obstacle to claimants, albeit one that doesn't really have any teeth due to its voluntary nature after initial contact has been made. Also, following the introduction of tribunal fees, many employers will prefer to wait and see whether the employee is prepared to put their money where their mouth is. The problem with that approach, of course, is that once a fee's been paid, the employee may adopt an in for a penny, in for a pound mentality, want to get their money's worth and therefore be less likely to settle their tribunal claim. However, with ordinary unfair dismissal claims now costing claimants £1,200 to take to hearing, the fact is that achieving settlement at an early stage at no cost is likely to appear an attractive alternative. Before we conclude, a few words of warning. Unlike tribunal proceedings, where an employer will first learn of a claim in writing from the relevant tribunal office, the first an employer is likely to hear about an early conciliation case is when they receive a phone call from the Acas conciliator assigned to the matter. This means that the employer probably won't have had time to gear up for the process in the manner it usually would where an employment dispute is concerned. This obviously increases the chances of being caught on the hop and saying something that you could later come to regret. For a start, a dispute that will have given rise to contact from Acas is likely to be very recent. Emotions could still be running high, and words are more likely to be said in anger. This may serve to aggravate the situation and increase the likelihood of a tribunal claim. Similarly, the tactical aspects of conciliation could be overlooked, and an employer could end up giving away information that unwittingly serves to alert the individual that there may be better grounds for a complaint than first thought, which again could increase the likelihood of a tribunal claim. Resist the temptation to get drawn into an argument over the merits of the case from the outset. Instead, focus on gathering information around time limits, the actual prospect of litigation, and apply some subtle pressure in key areas, for example, asking the conciliator to raise the prospect of tribunal fees with the individual. It's often the case during conciliation that what you don't say can be as important as what you do say. If in doubt, it's usually best to adopt the least said soonest mended approach. Avoid ambiguity in your conversations with Acas, and be careful that your exploratory questions are not interpreted as actual offers. Alternatively, you can, and perhaps should, call ourselves, and either myself or one of my colleagues will draw on all of our experience in this area in liaising with Acas to achieve the most favourable outcome for you as the employer. That concludes this podcast on early conciliation. If you require more bespoke advice on this matter, or any other employment law related topic, then do please get in touch with us using these contact details. Thanks for tuning in, and bye for now.